right, Ms. Merchant, I'll hear from you on the proposed order.
Great. Judge, there's a couple things that are in this order that were also in the state's previous submitted order that we would object to. The state's, basically, they've included some language that we did not agree to and we do not agree to. They're saying that the waiver was the result of Mr. Duke's rational intellect and free will, which we never agreed to that, and we disagree with that. Rational intellect and free will, that was
Let's talk about that.
It was never discussed.
Ms. Hart, is that critical to the order?
Judge, I had cited to the Blackburn case, which actually predates Jackson v. Deno, so Jackson v. Deno would have incorporated this. And in order for a statement to be given voluntarily and knowingly, it in fact does have to be, that's the language from Blackburn v. Alabama and all of the cases that then cite that later. When Your Honor asked Ms. Merchant if they were stipulating to all the Jackson-Deno issues, this is included. That is one question that the jury will be asked to decide, but that's also a question that this court has to determine before the jury can decide it. It would be error not for the court to rule on that.
All right, and what's your next issue, please, Ms. Merchant?
And Judge, we do not agree to that
Okay.
statement being included, so if they need that, then we would need to litigate that. Judge, our next one is there's an incorrect statement that says the entirety of the verbal statement given to the agents was either audio or video recorded. After this, we subsequently came to find out that Agent Sheldell did other interviews with my client that were not audio and video recorded, so that is not an accurate or truthful statement, and we do not believe that that should be included. There are other interviews that were done, whether they want to call them conversations, interviews, meetings, there were other ones, and he's testified to that.
Let's see, and his statement was not induced by the slightest hope of benefit nor the remotest, I think it should be fear of injury, right, instead of...
Probably, yes, sir.
The entirety of defendant's verbal and written statement given to Special Agent Sheldell in Holland on February 22, 2017, both pre and post Miranda are admissible. All right, you're saying there were other interviews on that day that you were not aware of? Is that what you're saying?
Yes, there were, and we had that, when we had the bond hearing, those came to light. We found out after this that there were other interviews with our client.
Okay, well, what other interviews were there? There were the...
Back at the jail, he went out to there was an interview prior to the recording taking place, and then there was some interviews at the jail, and I quite frankly don't remember the dates. I haven't looked at that in a while, but there were some other...
This only addresses February 22nd, 2017.
So before today, the only order that I had was the state's proposed order that says specifically the entirety of the verbal statement given to the agents was either audio or video recorded.
Well, that's not what this one says.
And I'm not sure. I don't read it the same way, but I think that's what they were getting at, where it says the entirety of his statement given. As all I want to be clear about is that we are not agreeing that this was all he said, and this was the only interviews that took place. There were others. So I just want to make sure that...
Well, that goes back to my question. Others on the 22nd of February 2017 or other dates?
One was on that date, I know for sure, and then there were other dates as well.
All right. What I understood you to say was pre-Miranda, about 10 minutes.
5
5 minutes. Post-Miranda, both at the jail.
At the police department.
At the police department, okay. And then a video at this orchard type
Your Honor,
place.
yes.
And that's it?
Yes. No,
Or did you intend to include subsequent statement after returning from the orchard?
Judge, I don't know of any statements after returning from the orchard that day. Now, I am aware of and became aware at some point, I don't even remember when I became aware, it was the defense counsel who made us aware that Agent Sheldell did in fact speak with the defendant on other dates. However, he was represented by counsel on that date. There are no reports on that, and we have no intention into going into any of those statements because it would be violative of his Sixth Amendment rights. He had an attorney. And so that's why on the order that I'm presenting today, which is the only one I'm asking the court to sign, I'm specifically referencing February 22nd.
That's
correct.
It.
And now as to any allegations that there's evidence that there was another interview on February 22nd, 2017, I'm not aware of any evidence of that. In fact, Agent Sheldell has been very clear that he turned the microphone, the audio microphone on when the defendant came in. I think perhaps there was questions as to whether or not he had the audio recording device on him when he went out, got the defendant from the waiting room and walked him back into the room. But if anyone who's been to that police department, it's about a 2-second walk.
Yeah.
And so I'm not aware of any testimony, any evidence that he interviewed him prior to that recording device being turned on, and the recorded interviews would be the only thing that we're seeking to introduce at trial.
All right. I'll give you the last say, Ms. Merchant, if you have any further argument.
No, I don't. Thank you.
Okay, thank you. Over your objection, I'm going to execute this order as prepared.
Thank you, Judge. Even with the rational intellect and free will?
Yes.
Okay. And Judge, we would just want to make sure that it's clear that we're able to argue on the jury, in front of the jury, that we did not agree to that language. That's obviously something the jury needs to decide. We're not stipulating to that. So I don't know if the state plans on arguing that we stipulated to this and, those types of things.
I'm finding you did stipulate to it.
To free will and rational intellect?
That is what waiving any challenge to a admissibility of a statement is. Yes, I'm making that finding.
Okay.
Thank you. But it'll all come up again before the jury. Anyway, they can decide whether to give it any weight or credibility.
Yes, Your Honor.
That's just the gatekeeper. All right. What else from the state's perspective do we need to discuss?
Your Honor, we have filed a motion to exclude inadmissible expert testimony. This is through our discovery process. I guess, had come across that the defense intended to, and I'm not really sure who the expert is. We've not been served with any witness list with this particular expert. It was through the ex parte motions that we discovered that they intended to call a witness on false confessions. And of course, in this case, Ryan Dukes, as we just talked about in the Jackson Ditto hearing issue, on February 22nd, after being Mirandized, confessed to murdering Tara Grinstead here at her home in Irwin County. And through that confession, of course, they have, through these ex parte motions that have been heard before this court, they talked about calling a false confession expert, that his confession was gained falsely. And our first contention is that's inadmissible. We would have to have a Harper hearing. We've not been served with the name of this expert, a curriculum vitae of this expert, to know who he is, to be able to cross-examine him. It would require a Harper hearing just as we would have to have in the True Well. And we've not been provided with any of that information, number one. Secondly, to that, false confessions have been ruled inadmissible. I have 3 Georgia Supreme Court cases which cite other cases.
You mean expert testimony?
Expert testimony about
Yeah.
false confessions has been ruled inadmissible. All of them Supreme Court cases. The first one was a death penalty case, which seems to be the one that started kind of this genre of expert, which is Riley versus the state. Riley is at 278 Georgia 677, 278 Georgia 677, a 2004 death penalty case. Also, just for note of interest, it was unanimous Georgia Supreme Court. It was also denied cert by the U.S. Supreme Court.
What date was that? What year?
So
was
this
that?
is 2004, 278 Georgia 677.
Thank you.
And it's Riley. And the false confession expert was not allowed to testify in either the guilt or innocence phase or the sentencing phase of the trial. And the Supreme Court upheld that ruling in that case. And they go into the analysis of that, in that even their expert that they called said that false confession theory has not reached a verifiable study stage of scientific certainty. And we have much more research to do and more experience to gain in it. And that was the testimony at that time. And based upon that, the evidence in that case that was called, the Supreme Court concluded that the false confession expert was not allowed to testify based upon the Harper, and they even cite the Harper decision that false confession had not reached the level of scientific verifiability. This case has been cited subsequently. I'll point the court to several other cases to make sure I gave you all of the cites from that case I needed to give you, I believe so. Subsequently cited in Wright versus State, W-R-I-G-H-T at 285, 428, 285 Georgia 428, a 2009 case. Again, a unanimous decision from our Supreme Court, also denied cert by the United States Supreme Court. In this case, the defendant, Ms. Wright, challenged the exclusion of the alleged expert testimony about her confession and having the expert testify about false confessions. The Supreme Court, citing Riley as previously stated, stated in that case on, I believe this is page 431 of the opinion, pre-submitting the question of excluding their testimony because of discovery violations, there was no showing that false confession theory and the Reed method satisfy the evidentiary test in criminal cases set forth in Harper, which again is, brings up the Harper hearing. The Supreme Court in this case cites Riley. It also cites Vaughn versus State, VAUGHN, 282 Georgia 99, 2007, Lyons, LYONS, 282 Georgia 585, 2007, it was overruled on other grounds. And then most recently cited in a 2014 Georgia Supreme Court decision in Woodall versus State. Also, a unanimous Supreme Court of Georgia denied cert by the U.S. Supreme Court. It's 294 Georgia 624, 294 Georgia 624 in 2000.
Are all of those murder cases?
Yes, Your Honor.
Thank you.
And in this case as well, basically I'll just, on page 628 of the opinion, it says appellate contends the trial court erred when it denied the request to tender Dr. Richard Leo as an expert in police interrogation techniques and false confessions. This court has upheld rulings within the last several years that this proposed area of expert testimony has not reached the level of scientific reliability necessary to allow its admission at trial. The court then cites numerous decisions, Wright, as previously stated, Lyons, as previously stated, Riley, and then, of course, this case as well. And so based upon the Supreme Court precedent, we would just ask that the court exclude any testimony regarding any false confession expert. If and when we are provided with that name and that person, and to have a Harper hearing result, but otherwise to exclude that testimony, we would be asking for that if we ever have that hearing.
Does 2015 seem to be the most recent comment from our Supreme Court?
That does seem, it's 2014, but it does seem to be the most recent comment. Yes, Your Honor.
2014. Thank you. Okay, Ms. Merchant, any response or argument?
Yes, thank you so much, Judge. Judge, a couple things. Again, we have not filed an expert on this issue yet, and quite frankly, I'm not sure what we will be doing on that. It depends a lot on what the state argues in their case. I am anticipating, and the reason that we wanted funding on that is I am anticipating the state will present the statement that Ryan made to Agent Sheldell as the truth. I assume that's what the state's going to argue. They're going to argue this is a truthful confession. Well, then in rebuttal, we have the ability and should have the ability to argue that this is actually not a truthful confession and the reasons that it was not valid. That's what we would be asking to do if that time comes. If the state does not present this as a truthful confession, then we don't have the need to rebut it. But I assume they're going to be doing that. I assume they're going to be putting this in and saying that this is valid, and I assume they're going to have Agent Sheldell testify about why he believes it's valid. And we have the right to put into evidence why we believe it's not valid. One of the techniques that was used, Agent Sheldell testified to previously, was the Reed technique. The Reed technique is a technique where it's a coercive method. It's been deemed coercive by many courts. A technique to pressure people, and it's more likely to lead to false confessions. If Agent Sheldell goes into that, which I assume he will, about the techniques he used in gaining this confession, we should have the right to then explain in rebuttal to Agent Sheldell's testimony why we believe this testimony and this confession is not a confession.
Through an expert.
Through an expert, yes, Judge.
Well, when would you propose to have this
Analysis.
Well, if we plan on introducing an expert in our case in chief, if we plan on doing that, then we have to file that within 5 days prior to trial. So, and then before that expert testified, we'd have to have a Harper hearing on if they were testifying about false confessions. I don't know that we're going to have them testify about a false confession theory. So I'm not really sure we're happy to work on the parameters of what they're able to testify, but I can tell you at this stage, it is my anticipation that the state is going to put in people, whether they qualify them as experts or not. They have experts on their witness list. They have false confession experts. I have interviewed their purported confession experts. So they've got currently on their witness list experts in confessions. So we then need to be able to put up an expert to counter their expert in confessions. That's only fair. And so I don't know what all they're going to be putting in. I assume they're going to be putting in this statement that they claim is this truthful confession. I assume that. And I assume they're going to be arguing to the jury all of the points that make this, in their mind, a truthful confession. We then, in turn, should be able to put in all of the reasons through an expert who can explain this, why we disagree with their expert and disagree with their theory that this is a truthful statement. On to the law, though, that the state fights.
Well, let me ask you, but they've notified you of their experts. Didn't you just say you've seen their names
The
on
first trial, yes.
Okay, so you have them.
Yes, and I actually don't have the witness list in front of me.
Sure.
Because I didn't know that that was going to be one of the things that they raised, since they didn't raise that in their motion. Whether or not it's been
This
disclosed.
motion says that they anticipate you will attempt to introduce evidence related to false confession theories. The state moves the court to prevent any such evidence as it does not meet the standards set forth in Harper.
Right, and we haven't submitted that. We haven't submitted a report on that. We haven't submitted any of that as to whether or not there's going to be a false confession expert. But if the law, I can argue the law
Okay.
while we're here, since the state wanted this heard today. I think it's premature, but since the state wanted this heard today, I'm happy to argue the law on
Okay.
it. Judge, the cases in Georgia that the state cites, none of those were a rebuttal type situation where the state was putting forth this confession saying that this was a valid, voluntary, wonderful, free will confession, and then the defense was trying to rebut that assertion. These were ones where they were trying, as their entire theory, to put forth this false confession theory. It's different if the defense is trying to just rebut what the state has already presented, which is what we would be doing in this case.
I'm not following you, I'm sorry.
No,
All right, the state had presented the statement as a true confession.
Right.
The defense wanted to present an expert on false confessions. Isn't that to rebut what the state put up? I don't understand.
Exactly. Yes, that is exactly accurate. Yes.
Well, that's what you're talking about doing, is rebutting
Yes.
the states, and that's what those cases were about, no?
No, these were different. So, and they're not, unfortunately, they're not very detailed opinions. But in one of them, for example, let me see, the Lyons case, the one that the state cited.
In the brief, yeah.
Yeah, they, in that case, the defense expert was going to testify about police interrogation techniques, and that the issue of whether certain interview techniques could result in a greater likelihood of false confessions, and then asked to impart specifically about the defendant's case, and then how interrogations work. It's different, and it's hard without having the testimony before the court to explain, but there are certain things that were present in this case. The voluntary consumption of drugs, for example, psychological factors, things like that were present in this case that the normal juror doesn't understand unless they get expert testimony on it. And so we believe that Agent Sheldell is going to say, I don't think he was under the influence of drugs. So then we are entitled to bring an expert to say, he could have been under the influence of drugs, and this is what that looks like. Because otherwise, all the jury's left with is Agent Sheldell saying, I don't think he was under drugs. No, I asked him that, and he said no. And that's all they're left with. How do they determine if he was under drugs or not when all they're left with is Agent Sheldell's testimony that says he believed they were? I mean, maybe the state's not going to put forward all that, but we're anticipating that they are, and so we're going to have an expert lined up in case they do. We think that there were specific psychological stressors given Ryan's physical health at the time. And so we think that those are relevant to why he might have told law enforcement something that was not true. The case law, just back to the state's argument as far as the case law, this is an evolving theory, and that's always the case when we have scientific evidence. We currently have Harper. We're about to get Daubert. Thank goodness. I was lucky enough to testify in front of the state legislature, and they have passed Daubert. So we will soon have Daubert. Not by May, but later in the summer, we will have a Daubert standard. But looking at that Daubert standard, the court is supposed to look at the evolving standards of scientific evidence, okay? Right, and false confessions is, exactly. False confessions is a perfect example of that, Judge. There was a recent study that revealed that, post-conviction DNA study, it revealed that 354 people were wrongfully convicted, 28% of them had falsely confessed. This figure alone shows that this is an evolving area of research. The research has also revealed that the police apply coercive procedures just like the Reed technique that we had here, and that those combined with other factors like psychological factors lead to a likelihood of a false confession happening. And
Well, you
we
would,
should-
of course, it would be incumbent upon you to present that evidence at a Harper hearing in that regard, correct?
Right, if we are going to present that type of an expert, yes. Judge,
Exactly.
yes,
Okay.
yes.
Or any other expert, right?
Yes, yes, and to give notice pursuant to the statute, yes,
Great.
definitely.
Great. Okay.
But there are two circuits that I just wanted to point out for the court.
Sure.
Since, again, I think this is a little bit premature, but I want to point it out since we're arguing it. There are a couple cases. There's a Seventh Circuit case, it's a 1996 case, where the Seventh and the First Circuit have both admitted false confession testimony. So the Seventh Circuit is United States versus Hall, and that's 93 Fed 3rd, 1337. And again, that's the Seventh Circuit. In that case, they permitted an expert to testify generally about false confessions. Then United States versus Shea, which is 57 Fed 3rd, 126. That's a first circuit case. And in that one, they also permitted an expert to testify that the defendant suffered from certain mental disorders that would lead him to these false confession type situations.
Were those Daubert states?
They are. Everybody.
Daubert circuits?
I learned everybody's Daubert state with us.
How about that?
I think maybe Mississippi. There's one other southern state that wasn't, but
Well, Daubert was specifically excluded, I think, from scientific testimony when they adopted the federal rules, pretty much, as I recall.
it was.
But
Yes.
anyway, okay, but that's changed. Okay,
It
thank
was, and Professor Milich testified about that at the hearing in subcommittee. It's been an interesting battle, but Georgia's coming around to Daubert. But there's also a couple states that have also permitted this testimony, Judge. Alaska, California, Texas, and the Southern District of New York. The Ninth Circuit has permitted it, so we've got quite a bit of circuits that are admitting it. Also the Fifth Circuit, Judge. So there are a lot of different circuits, and I'm happy to cite that if we do move to admit this under Harper, which I think will still be the standard when we go to trial, submit all of those cases for the court to
Okay,
consider.
thank you. Well, I noticed this, it was on our list, and I noticed that this motion to exclude inadmissible hearsay testimony or expert testimony was filed July of 2021. So I'm going to go ahead and sustain your motion. If and when you decide to put up any expert evidence, we'll have a Harper hearing and may change my mind, but today your motion is sustained. All right.
Would you like me to prepare an order about
Please,
that?
yeah, please prepare an order in that regard.
We have
Okay.
a chance to review that. I just want to make sure that the order just
Sure. if you'll
goes
just copy-
into that it's just sustained. Okay.
All right.
Thank you.
Anything further from the state side that we want to take up today?
Judge Dave, motions, just to discuss the scheduling of Jason Shadell's testimony and how that's going to occur.
All right.
And
Any-
also Mr. Bo Dukes, I apologize, forgot.
Yeah, before we do that, anything else?
On that end, Mr. Dukes, I don't remember if I told the court yet. I talked with Ms. Mullis at the break at lunch, and she's available tomorrow.
Okay.
Judge, I actually texted her since then, and we may or may not be available tomorrow. We have calendar call at Wilcox, and we have trials in Chris, but we're kind of we don't know where we're going to be. But
Tomorrow's Wednesday. Well, we had set aside today and tomorrow, right?
it's not really me, it's Ms. Mullis that's the issue.
I guess. All right.
She told me that her assistant district attorney, or assistant
Public
public
defender?
defender would cover Wilcox. She was aware of those when we spoke.
Okay. So she can be here tonight.
That's what she told me.
All right. What time? You want to start 9:30?
Judge, so, two things. One, I had asked that if we were going to have any testimony tomorrow, because of people that weren't available today, that I'd be allowed to, appear via Zoom. But either way, whatever.
I hadn't seen that, but okay.
It was one of the many, many emails that went back and forth yesterday, Judge.
Yesterday, okay.
Yes, sir. That being said, if Your Honor wants to do it at 9:30 tomorrow, we'll make ourselves available.
All right. Let's do that. We'll see y'all at 9:30 in the morning, and then we'll decide about Mr. Shadell at that time.
I apologize. I had
Go
one
ahead.
question.
Yeah. Hey, listen, I want to talk about some more. We need to talk about this questionnaire before again.
Oh, I thought that had already gone
Well,
out.
as of last time it was ready to go, I just want y'all to take a look at it again, and if it needs updating, it needs updating.
Mrs. Ross had asked us that in an email sometime back, and I believe
Right.
both sides indicated that we didn't have any recent changes from the last time it went out, and that,
Okay, all right, that'll be fine. We'll just go with that. Go ahead.
just to be clear, just so going forward, making sure that Ms. Mullis is here tomorrow and making sure that Jason Shadell appears whenever that is scheduled for, as he is not the state's witness. I just want to be clear, the state does not intend to make sure he's present. They do have the ability to contact him. They in fact sent him a subpoena yesterday morning. And so we just want to make it clear on the record that we don't intend to get them present unless the court specifically directs me to do that.
Why don't I call him and see what's best for you? Do y'all object to that?
Not at all, Judge, we
All right.
appreciate it, thank you.
Have you got, can you just, somebody give me his contact
I can.
information? You don't have to do it on camera.
Yes, sir.
So just give that to me later, okay? All right, anything further then? If anything comes up with Ms. Mullis between now and 9:30 in the morning, let me know. Otherwise, we'll be adjourned until that time. Thank y'all.
Thank you.